I will tell you that my understanding of the history is that it was exactly as Tom Haynes said. It was that the artist should be the one who gets to make the decision whether they give it away or not. And some people made that choice, some people didn't make that choice. But the purpose, remember that prior to, the reason it was a radical notion in the 18th century to give the artist the right, is before then it was the publishers who were the 18th century equivalent of Disney, okay? The publisher automatic, or whatever corporations one thinks about when one thinks about large media corporations now. The 18th century equivalent of the large media giants were the publishers, especially the big successful publishers in the United Kingdom. Those folks started off owning the copyright automatically. What the US Constitution did is it said, no, the media companies don't own the copyright from the get-go. The artist owns the copyright from the get-go. So then that is clearly what the US Constitution says. But there is a balance to this, as in all law is about balance and looking at individual cases and applying facts to these balanced laws. The balance to the rights that the individual artist has under the Constitution, it's actually Article 1, Section 8, is an amendment to the Constitution, which is the First Amendment, and it's the first, many people will argue, because it's the most important amendment, and that is the amendment that gives everybody a right of freedom of expression, and a right including both in terms of disseminating news and discussing politics, and freedom of expression relative to making comments on news and art and politics. So what you have coming out of the United States Constitution is, in the body of it, it says, you're an artist, you have a commercial right which you can choose to exploit the way you want. It's your choice of the artist. And then you have the First Amendment saying, but it is extremely important, and this is again, Tom Jefferson, Tom Paine, they were all there on the First Amendment issue too. It is extremely important, if this system is going to work, that people be able to express themselves in art, in all media, and there was no doubt they would say in film, to comment on what other things are going on in the society and in the polity. So that's the foundation, okay, the constitutional balance. Out of that, we've had a series of dozens and dozens of laws and amendments to the Copyright Act. First one was passed in 1790. It's been amended and updated many, many times. And we've had literally thousands of cases interpreting how do you strike that balance between the First Amendment right to comment on other people's artwork and include other people's artwork in your work, and the fundamental constitutional right of the original author to have certain property rights. It's called intellectual property, it's property right, in the work that they create. The latest application of this balance, this constitutional balance, is in the current Copyright Act, and it's Section 107. It's what we call the Fair Use Act. It's the Fair Use section of the Copyright Act, Section 107. And what it says is, despite the rights, the intellectual property rights that you have as a creator of a film or anything else, another artist has a fair use to use certain portions of your work in a limited context. And then it gives 4 factors, which I'll discuss in just a minute. But the thing I want to be clear about is actually 2 points to reiterate. Number one, the Fair Use Act is an attempt to strike this balance out of the Constitution. Number two, unfortunately for you, but perhaps fortunately for lawyers who charge by the hour, there is no hard and fast rule. And anybody who tells you that you can, if you do 10% of a work, or 9% of a work, or 20% of a work, you're automatically safe under the Fair Use Act, is unfortunately speculating. Sometimes it works out that way, sometimes it doesn't. Every case is done on a case-by-case basis, taking into account all of the facts of the particular case. And my strongest advice to anybody who is thinking about what do I want to do relative to using somebody else's artwork is do some planning ahead of time, get some advice on what are the risks. And as you're going to hear here, the risks may not be considerable of using somebody else's work in many instances. On the other hand, you should make an informed decision before you use somebody else's work as to whether or not there is a serious risk. So let me run through the 4 factors, and then I want to wrap up and turn it over to my fellow panelists. The first factor that the courts look at is, what is your purpose in using the portion of somebody else's work? In other words, what are you going to do with it? If it's a purely educational use, it's for a nonprofit sort of use, the courts are going to look much more favorably upon your using somebody else's copywritten work than if, for instance, you're going to incorporate it into a more purely commercial activity. So that's one factor the courts will weigh when they're weighing these 4 factors. The second is, what is the nature of the work that you are copying portions of? If you are copying something that is primarily factual and did not have, say, a nonfiction article which was much more heavy on the facts than on the creative writing portion, the courts are going to tend to say, you know, facts are not owned by anybody. It's the expression of the facts, the expression of the idea. Where conversely, if you've written a brilliant piece of haiku poetry that has no facts in it, the court is going to say, that's a purely creative work. We're going to discourage copying of that. The third factor is, what portion of the work did you use? Did you take, out of a 100-page novel, did you take 100 pages? Well, that's going to cut against you. Out of a 1,000-page novel, did you take 1 page? Well, that's going to cut in your favor. So what portion of the work did you take? And then the fourth factor, which the US Supreme Court, more times than not, says is the most important factor, is what is the commercial effect on the rights of the original copyright holder of the second artist taking a portion of the first artist's work. In other words, if you make a film and you take a large portion of a, let's say, an earlier filmmaker's work, is the second work going to diminish the sales and the commercial value of the first work, or conversely, is it going to perhaps enhance the sales of the first work? So what is the commercial effect on the second of the second work on the first work? So those are the 4 factors that, again, get weighed on a case-by-case basis in every single case. Everything was kind of going along swimmingly with the application of the 4 factors and the whole rule of the whole evolution of legal history on copyright until sometime in the 1980s, 1990s, when the digital, what I think is fair to call the digital revolution, really got traction. And I think that the prevalence of digital technology and the digital literacy, if you will, of vast numbers of people around the world, and the ability that the technology puts in the hands of people who are able to use it to literally copy parts and, in their entirety, works of other artists, has radically changed both the ability to copy as well as the ability to so-called police conduct of people who are using other people's work. And has simultaneously raised the financial ante so that the revenue of companies like Disney is, because of digitization and able to do international distribution on a digital basis, is substantially higher than, say, the revenue of those publishers in the 18th century. So I think the game has really, really changed in the commercial world, and of course the law ultimately has to help regulate the commercial world and the artistic world. So we are indeed at a juncture where the law, while it is evolving, perhaps has to evolve more. And I think part of what we're going to hear now is directions that it might evolve in.
Well, okay, that's fine. I'm glad you brought up these issues, especially about technology. And in a lot of ways, it's great that you've sort of reviewed the sort of the history here. Thomas Paine happens to be my personal hero, as well as Ben Franklin, the original zinester. But the thing is, in a lot of ways, this technology issue is sort of mooted out. A lot of these so-called fundamental structures and understandings, and also you seem to be focused on this idea of John Locke and this individual ownership kind of thing. And in most cases, in fact, copyright is not held any longer by the individual artist, in fact, by corporations. So it's kind of moved back to the original situation before the Enlightenment. And so that's really what I think a lot of this work is, which is not so legalistic, but more this groundswell of people making their own work. It's not so much of them declaring their rights, but more of a taking back from the corporations who have this almost kind of exclusive control over the science and silence of our culture today.